The writ petitions are accordingly dismissed.
Obliged, Your Lordship.
Ali, good morning. I'm next to you. I'm told from my cousin. I'm done with it.
May it please the Lordship.
Yes,
I beg to mention item number 1, Lordship.
yes.
My senior has a hearing matter on court number 1, Lordship.
Ah.
Kindly adjourn for the day, Lordship.
No, we'll wait. He will not be in court number 1 for the whole day. We'll wait
Lordship,
for him.
kindly adjourn for the day, Lordship.
Why?
Only for the day, Lordship.
Why only for the day?
There is a hearing matter, Lordship, court number 1, Lordship.
Which item is it?
Item number 6, item number 6,
It
Lordship.
will not take whole day.
Lordship.
This
there
is a simple
Nia
matter.
Lordship, actually, there.
Huh?
Nia Lordship matter. Next week, Lordship.
You said for the day. Tomorrow?
Tomorrow.
7.
Lordship, next week, Lordship. No, yeah, code number 1. No? Yeah, item number 1.
You see, this is in the hearing list. We've got so few matters. Item 2 also is going to be adjourned. They've also already made a written request. It's a bad case. Is it a bad case?
No.
Huh? No,
I think.
you don't know the case.
Lordship.
Have you read that matter?
Yeah, eyewitnesses, my
I know. In fact, the daughter is the one, the mother died.
Only for today, Lordship.
Tomorrow? Okay, right. On the prayer for adjournment made on behalf of Mr.
Please, Pui Goswami.
Miss B. Goswami.
D Talukdar, my senior name. My name is P. Goswami.
Acha, on the prayer for adjournment made by Miss B. Goswami, who submits that her senior is having a hearing matter in another court. List the matter tomorrow.
My Lord, I beg to mention item number 2, my Lord.
Yes, why do you want to adjourn? You've been adjourning this matter time and
In
again.
this case, my Lord, and the appearing, my Lord, his
Huh?
mother is sick. His
Mother.
mother is sick, my Lord.
Whose mother?
LJ Das.
N.J. Das.
My lord, there's an analogous matter where I am appearing, my lord. They have neither intimated us also regarding the adjournment. Because I like to do the matter. The rest of their part, they can do it anytime, my lord.
Problem is, Mr. Counsel, the thing is that I did not read this file also because
Even I did
Yesterday,
not-
they made a written request.
and they took my signature, even I
They
didn't.
took the
go through.
signature of the PP also, who has not objected.
It's a criminal appeal, we can start it.
No,
together,
that
my
is
lord.
all right. I could have done the same, but then you see, then because we are ready with others. That is it. Otherwise, if it had not been, if a written request had not been given earlier, which had not been accepted by the PP, that would have been a different issue.
But PP is very smart, my lord, here. She can always continue with from the,
It becomes a problem for us to keep it pending,
I can understand, my lord.
because
Yeah.
already one matter.
What
was kept-
happened, my lord, because of that letter, the probably lordship has not prepared.
Yes,
And because of non-serving of later, I am prepared, my lord.
you should have told the other side also. I mean, your
Yes,
the other appellants councils. You should have told them.
yes.
They should have told us.
Should have told them, then at least he wouldn't have wasted his time also yesterday evening.
Tomorrow, day after, tomorrow that.
Because I
Demaji is
Tomorrow,
there, so-
tomorrow heavy matters.
Demaji is there, so day after.
Dimaji matter is there, and then this matter is.
Thursday, my lord.
This week might be a problem after Wednesday because we might have to hold a court for 2 days somewhere else.
Okay.
So after a week, right,
Problem.
on the prayer for adjournment made on behalf of Mr. N.J. Das, whose mother is reportedly ill. And which has not been objected by Miss S. Jahan, learned additional people. This is the matter after it.
On 14, my lord. Then.
Fourteen. This is the matter of 14.
Publish.
Not Vijay Lordship, for listing of a criminal jail appeal Lordship. Earlier listed on 16/5/23 Lordship, and Honorable Court is directed to list the matter after 2 weeks, but it was not listed Lordship. Can it be on 16th of June Lordship?
Have you taken the consent of the, have you asked the registry to fix the matter?
No Lordship.
Why don't you ask the registry to fix the matter? Then you come here if it is not done.
But I will contact.
Okay, because they have got a certain queue. Okay. Next.
Apply.
Right, please, your lordship. Lordship, I am praying for listing of a criminal appeal, my lord, on next week, any day, my lord.
Why?
My lord,
Why
for
don't you ask
regarding
the
a
registry
bail.
first? Why don't you ask the registry first? Ask the registry to list the matter, then you come if they don't do it.
Like, okay. Okay. Apply.
May please tell me. It's a POXO.
Let's see, I'm
This is item 3,
item 4.
4.
4, whatever, item 4, okay.
It's a POXO matter, so I think the live streaming should be.
Yes, live streaming has to be stopped.
Person chase him grievous injury by, caused him grievous injury by assaulting him with sharp weapon on several parts of his body and left him on the road. Then Sri Dharman Singh stopped his motorcycle and tried to catch the accused person, but accused person fled away from the place of occurrence. Then Dharman Singh chased after the accused person, but the accused person managed to run away. Immediately, 108 ambulance service was informed, and my nephew was taken to Hailagandi SK Rai Hospital, but doctor declared him dead. At present, the dead body of my nephew is at Hailagandi SK Rai Hospital. It is FIR. Kindly see page 9.
Page 9.
9. I just read relevant person. It is also the informant statement. PW1 Karunakanto Sinha. I know the accused person standing on that dock. On 29/7/2014, at about 9:30 p.m., while I was sleeping in my house, I heard how and cry coming from the road near my house. On hearing the how and cry, I came out from my house to the road and saw my nephew Harinder Singh was laying on the road in injured condition, in a pool of blood. Many people gathered there at the place of occurrence. Someone from the gathered people informed police. Someone, Lordship. Police come on the same night. I came to know from Dharman Singh, my neighbor, that while Dharman Singh was coming from the Kalaswara towards his home, after his arrival at village Kajagram, Dharman Singh saw the accused person Putu Das, Raju Das, Kalai Das assaulting my nephew Harinder Singh by means of a sharp weapon on the road nearby our house. And while Dharman Singh made attempt to apprehend the accused person, they started running away. But he chased them, but they fled away under cover of darkness. Ambulance came and shifted the nephew to the SKRI hospital, Hailakandi, where the doctor declared him for dead. I lodged the FIR Lala PS Exhibit 1 and FIR Exhibit 1 on my signature. Police recorded my statement. In defense lordship, I lodged the FIR on 30/7/2014 before Lala PS, which is 5-6 kilometers from my house. There is a outpost of Kalasara, which is about 1 kilometer from my house. The old Kalasara PW road has been diverted through the front of my house. My house is situated to the west of the point where the new and old road has been diverted. My house is near to the old road than the new road. There is a culvert in front of my house. We are 5 brothers. The father of deceased is my brother. My house and the house of the deceased are separated but contiguous. My house is to the west of the house of the deceased is the east. To the south of my house, the house of the master is situated. The master has 2 sons. It is a history also. To the further south, there is a abandoned house, and the further south, there was the house of Dabal, Dharmendra, Jiten, Bahadur, and Ada. The residence of Samkishore is far away from my house, intervened by 6-7 number of house. There is 2-3 number of shop near the house of Dabal by the said PW road. To the adjacent north of my house, the house of the Matilal is situated, and thereafter the house of Radha Kanto and Bhuvanjoy and Munda. Before my arrival, it is important. Before my arrival at the place of occurrence, the people gathered there. I cannot say the name of the people whom I found the place of occurrence. Around 30 to 35 people I found. After about half an hour of taking my nephew by the ambulance, I went to my house, and by the time all the people left the place of occurrence, those who gather from my same village and from my neighbor, Kalasada is a market area. The Kalasura road has been used by the people of 10 to 12 villages. The vehicle from Mizoram also flying on the road, and it is a busy road. The people from many villages do their market at Kalasura market, and people visit the market for my work daily, for many work daily. I do not know on the.
How does this evidence, how is it relevant?
Worship question is that in this, there is Dharman Singh is also.
Huh?
The informant pronounced the Dharman Singh is the eyewitness.
Government,
Dharman.
Huh?
This informant
informant,
pronounced Dharman Singh name.
I don't, huh?
He is the eyewitness.
The informant. No, Dharman is not the informant.
Dharman Singh
No,
is
no,
Pakar.
the informant is not Dharman.
Lordship, Dharman.
Huh? The informant is Karuna Kanta Singha.
Informant is
Dha-
Karuna
PW7
Kanta.
is
Huh?
eyewitness. PW7 is the eyewitness. He's
Huh.
the one.
Correct, no,
PW7.
he's saying informant's name is Karuna Kanta Singha.
Karuna Kanta
Yes.
Singha.
That's what
And he also pronounced the name of Dharman Singh.
he pronounced. Yeah, oof. You are killing the English language. Anyway,
Dharman Singh is eyewitness.
Huh?
Eyewitness.
eyewitness is Dharman
Dharman
Singh.
Singh.
Yes,
Correct,
PW7.
correct, that
So
much-
your lordship will take into account the evidence of PW7
Correct,
is reliable
correct,
or
that's all,
not.
that's all,
Yes.
that's all.
Like kindly, Lordship.
There's no, then, huh?
Dharman Singh statement is page 23.
Page 23,
23. Lordship.
he's the eyewitness.
PW7.
Yes,
I know all three accused person Putu Das, Kalai Das, and Dagudas, who are the residents of my nearby village. I also know the informant Karunakanta Sinha, who is my related uncle. On 29/7/2014, in the night about 3:30 PM, while I was returning from the market towards
9:30 PM, not 3:30, 9:30.
9:30 PM. 9:30 PM, when I was returning from the market towards my house by riding my bicycle, my bike. I saw the flash of my bike light, the accused person assaulting Farendra on the PWD road in front of his house. After I being reached near them, I stopped my bike, and then all three accused persons ran away. I chased them and ran behind them from about 100 meters, but due to darkness and heavy rain, I could not apprehend them, and as such, I returned to the place of occurrence. There I found many people gathered. I saw blood oozing injury of his abdomen, chest, and head. In time, police come, ambulance also come and took him to Hailakandi Civil Hospital. But the same night, he succumbed. Police recorded my statement. At about 9:10 PM, I went out from my house for Kalachora market. I went to pharmacy of Mulla to purchase medicine for my daughter. Thereafter, I also went to another pharmacy and did not get the medicine, but both pharmacies were found closed. I cannot say the name of the owner of the both pharmacies. The distance between the market and the residence of the deceased Harendra is around half kilometer. It is dark night, and due to heavy rainfall, I did not find any person on the way of my returning from market. While I was going to market, I found all three accused persons were coming from market side. In the market, I did not say other person as I went to purchase medicine. In the evening hour, people gather in the market. There is a police outpost in the market. I was in the market about 5 minutes. Police did not seize my bike. While 2 to 4 minutes, I returned to the place of occurrence after chasing the accused person and found that 15 to 20 people present there. After 5 to 10 minutes, police come. I did not inform police about the incident, but when my statement was recorded, I narrated entire incident.
Yes, what do you want to say? What do you want to say?
Page 82, Lord, kindly.
Yes, no, first of all, before we go to page 82, what do you gather from the evidence given by PW7?
Question is the PW7 tells me 9:30 PM.
Huh?
He saw 9:30 PM somebody is assaulting him. But in 82, this police is informed by Nazrul Khan. He informed police 9:05, Lordship. Kindly see, Lordship, page 82.
Page 82.
82. GDNT is 476, Lordship.
Page 82.
82, Lordship.
Yes,
9:05 PM, Lordship. Received the information, entry made. Entry number 476, Lordship. GDNT number. Dated 29/7/2014.
this is the
Now-
GD entry.
GDNT, Lordship. Now, Sri Nazrul Khan, son of late Abdul Matlib Khan, residents of Sarvanand, Sudarshanpur, Part 3, arrived at this outpost and informed verbally that a person is laying injured beside the road of Rajagaon. He saw this person is 9:05, he saw this person is also, but in
So there is,
Government Singh
so-
says 9:30 PM, Lordship.
so there is some minor discrepancies.
It is not minor, Lordship.
According to you, it's not minor, but the fact remains that
Police-
someone died.
Police also enter in 9:10 in that place, Lordship.
Then what else?
It is also recorded by DM Sharma, SI, Lordship, Dijumani Sharma. Kindly 28 page, Lordship. Dijumani Sharma, what is said? 28, kindly, Lordship.
Yes, page
Dijumani
28.
Sharma said, Lordship, on 29/7/2014, I was posted at Kalaswara outpost under Lala PS as in charge SI of police. On that day at about 9:05, one Nazrul Khan appeared to outpost and informed me that one person was laying on the ground in injured condition at Rajagaon by the side of road. Then I made DDNT 476 dated 29/7/2014, Exhibit 4 is the extra copy of the said DDNT. Thereafter, I along with staff went to the place of occurrence. After information of Nazrul Khan, he go to the place of occurrence, Lordship, and found Horen Singh is laying on the, this is person is laying on the road, namely Gaglasora Road, Rajagaon, with grievous injured in unconscious state. Immediately, I arranged from 108 ambulance. Police is also arranged, Lordship, and shifted him to Eskera Civil Hospital, Hailangandi. It was heavy rain on the relevant night. I prepared the road sketch map and place of occurrence by the Exhibit 5 and 5.1 is my signature. From place of occurrence, I see one pair of plastic sandal, black color, and also see one piece of Burmese sandal and of left foot, and one torchlight, 2 numbers of battery, one black color inner Genji by the Exhibit 2, and so on. The material exhibited being seen by me in the court I recorded the statement of witness. On that night itself, I apprehend the accused Kutu Das. After lordship, question is that after murder, anybody can stay in his room. No lordship.
Huh?
After murder, in recent, after murder, anybody can stay in his room. No lordship. But police, immediately police come to his, go to their room and they arrest. They said they're not, when they call, they come out and arrest. Is it possible?
Okay, your case is that if they had really committed the murder, they would have absconded. They would not have been staying in their own house.
No.
That is your case.
Normally that's possible. And there are no relation with, he is from Manipuri community, he is Bengali community. Bengali means tea garden level. No any relation, no any intention, no any cause. How can they, no any previous history also. Why they murder? That's why our court has also excused and released them on bail.
You see, that is a different issue, whether they are released on bail or anything. Now we are on the merits of the case. You see, the thing is that, was there any enmity between this PW7 and the appellants?
Means PWD7, when PW7 said in front of all gather, he just saw Kutu Das, Raju Das and Kalai Das is running. It is also in
Is running.
161 statement, lordship also. it is.
They were running very fast or running very slow?
No, lordship, it is, question is that heavy rain, anybody can run, lordship.
Anybody can.
Anybody run.
Yeah, why were they running in the rain?
In the meantime, there is a rain, lordship, heavy rain.
So they wanted to run in the rain,
Run.
the appellants.
Uh,
Singing some Bollywood songs while running or what?
Lordship, in 161 statement, it is also clearly.
What's it doing?
Yes.
Whose statement?
PW3, PW5,
To what effect? What is the statement made by those PW3 and 5?
PW3.
What are they basically stating?
It is contradictory, lordship. PW3, that is Sanjeev Sinha. Sanjeev Sinha tell the court in 64 statement, he said, Dharman Singh saw the 3% is. But in 61 statement, he said that Dharman Singh just tell them some 3 persons are running. And he want to test them, but due to heavy rain, he not.
So let us see PW3. What else is it?
PW3, lordship. PW3 is the page 13, lordship.
Yes, please read.
Page 13. I know the accused person. The informant is my father. He is the son of informant, lordship. On 29/7/2014 at about 3:30 p.m., I was in my house and at that time I heard how and cry coming from the PW road from the east side of my house, and I ran there and found my cousin Haran Singh laying on the road in injured condition. I noticed step injured at his chest and abdomen. I also noticed injury at his head. Many people gathered there. After about 10 minutes, Dharman Singh of our village came and running to the place of occurrence from the southern side and told us that the accused person Raju Das, Kutu Das and Kalai Das of village Kalapahar assaulted my cousin and fled away, lordship. It is a statement. But
So he has stated.
But 161 statement, lordship, he said, The Kalai Das, Raju Das and Putu Das, Raju Das and Kalai Das from village Kalapahar were running on the time. He tried to case
Page. 161 statement,
161 statement is not in
not
paper
at the,
book, Lordship. It is also in
is
file
before the police.
before police.
So what was stated there?
It is in vernacular language, Lordship, in Bengali. I also translate it.
No, she's there.
It's in Bengali one, right? আমার নাম আর ঠিকানা উপযুক্ত his name is Sanjeev. উপযুক্ত মতে দিলাম আমার বয়স অনুমান চয়নছো আমি হাল্লা শুনিতে ঘটনা বাহির হইয়া রাস্তার আমিয়া দেখি যে কেবা কাহারা রবীন্দ্র সিংহকে বিড়াল অস্ত্র দ্বারা আঘাত করিয়া জখমী অবস্থায় পিডব্লিউডি মতা কলাইয়া যার এখন চয়নছো regarding the injury he's telling my lord, কিছু সময় পর ধর্মেন্দ্র সিং বাঁকা দৌৰাইয়া আমিয়া বলে যে পুতু দাস ৰাজু দাস আৰু কালাই দাস সকলে কালা পাহাৰে দৌৰাইয়া যাইতে দেখে He
Dodai
saw them running away. So anyway, they were there.
not assaulting.
And that is a statement made by whom?
Sanjeev Sinha.
By PW3.
Yes.
PW3.
So what is wrong?
Not only the PW5 is also same, Lordship. Same statement there.
He is the hearsay witness. Direct witness is the PW7, my lord.
PW7, 5 also tell, he show that Dharmen Singh tell that somebody is running, Lordship. It is a running. Not sure he is assaulting or also stabbing, Lordship. It is not stated. But in court, it is contradictory. To differ this, Lordship. This alter of statement is benefit of accused, Lordship, right?
Huh? This
Alter of statement.
alter of statement.
In that is 61 and 64, there is the alter. At first he said he is running, now he said he is assaulting, Lordship. It's contradictory, Lordship.
Okay. I've got to undergo a English course, English speaking course after some time. Anyway, yes.
So, Lordship. My argument is this, Lordship. First point is that
Time. Your first argument is time.
argument is time, 9:05 and 9:30.
9:05 and 9:30.
9:30, Lordship.
Yes.
It is. Number two, Lordship, PW3, PW5 and PW6 statement is 164 and 161 is there is contradictory statement.
164 and 161 is contradictory.
Contradictory. PW3, 5 and 6. Lordship.
Yes, then
Then also, Lordship.
because they are saying that in their 161, they stated that Dharmen Singh
Hmm.
only saw the appellant's accused running away.
Running.
However, in their evidence before the court, they said that Dharmendra Singh had told them that he saw them assaulting the deceased.
It is. Number three, Lordship. Objective motorcycle is not seized, Lordship.
Motorcycle, what has the motorcycle to do with it?
Question is that, Lordship, it is a heavy rain.
Huh.
And Dharmen Singh is coming from Kalasara Bazar. And he saw his motorcycle light, the 3 persons are assaulting.
No, it's cycle light,
No, motorcycle, Lordship.
motorcycle.
Lordship,
Bike light.
Huh?
Flash of bike light. From the flash of the bike light.
Bike light means motorbike.
motorbike,
So motorcycle not seized.
not seized.
Why should it be seized?
Lordship. Only sandal and t-shirt is also.
Huh?
Only sandal, t-shirt and torchlight.
So sandal, whose sandal was seized?
It is not. match
Sandal and what was seized? Sandal and torchlight.
Torchlight.
Whose,
And
tor- whose,
one-
tor- whose torchlight?
one black t-shirt, but it is not match, Lordship. So
Black t-shirt.
question is that, Lordship, three persons are accused, three person. If the t-shirt is, whether the size is same or not, it is not matched. Also, sandal is not matched, Lordship.
Those materials are lying in the place of
Huh?
occurrence. The seized materials, as per the evidence.
It was raining, it
Like
got stuck in the
this
mud,
was-
they ran away without the chappals most probably.
Living, yes.
So, my Lordship,
So one of them will be missing a chappal the next morning.
also, they said a heavy forceful weapon is there,
Forceful weapon.
but weapon is also not.
What
seized.
forceful weapon?
It is also in pointed.
Okay,
Murder was-
we'll just take a 2-minute break, okay?
Lordship, in point 4. I said, heavy and forceful object is also in medical report.
Huh?
In medical report, it is quoted in page 27. Moderated, heavy and sharp forceful object is used.
Page 27.
27. Lordship.
27. Yes,
In my opinion, that
on
paragraph.
posted at so.
in my
Ah,
opinion,
no.
cause of death is
Stab
due-
wound. Stab wound.
Yes. Phone number is also all the findings then, in my opinion also. Second paragraph.
Ah.
In my opinion, the cause of death is due to irreversible hemorrhage, shock and respiratory failures due to stab injury and chest and abdomen by pointed, moderated, heavy, sharp, forceful object. But this heavy, moderated, heavy, sharp, forceful object is not seized, Lordship. Not recovered, Lordship. And 5 is also Nazrul Khan is the vital point, Lordship. He is first GTNP.
Huh?
Nazrul Khan, GTNP who is first informer, Lordship. In rolling, sometime it is the first FIR.
In rolling sometime?
It is called first FIR, Lordship.
What is called first FIR?
I also.
Okay, then before lodging. Okay.
The prosecution witnesses have, in fact, Lordship has named, most of the prosecution witnesses have named
Have?
Nazrul Khan.
Ah.
He had, in a sense, witnessed the incident and
Was not examined.
he was not examined.
Narul Khan examined.
Not
not-
examined. And PW7, somewhere it is written, I came to PW1 as in his evidence has said that he came to know from. Firstly, PW1 is a hearsay witness, Lordship. Because.
We'll hear you, madam, we'll hear you.
Nazrul Khan is not examined, Lordship.
Who's no, that is that person.
Nazrul Khan-
The page 82.
Nazrul Khan is page 87.
Najrul Khan, page 82.
Page 82. He is the first informer. But he was not examined.
Was he made a witness?
No,
Not made a prosecution witness?
no, no. Third lordship, another lordship point is that the deceased was unmarried person,
Deceased was unmarried.
unmarried person,
So,
about 36 years old.
so how does
Whereas
that matter?
Injury state because of extramarital affairs. Huh? Extramarital affairs.
Acha, injury because, okay, because he had an extramarital affair.
Maybe lordship,
Maybe.
maybe lordship. It is also.
How can we go on maybe?
It is
So,
page,
yeah.
page 11 lordship.
Page 11. Yes,
Informant also said lordship. I just from page 10 something lordship. He is age about 36 years and unmarried. I do not say whether my nephew kept himself under influence of liquor and drunken condition. It is not the fact that my nephew was a drunkard and I suppress the material fact. At first, the police from Kalasara came and the in charge was Dijamani Sharma from Manipuri community. There is a prayer hall in Christian community situated to the south of my house, inverted by 4 numbers of house. The house
please,
of
please read the words properly also. It doesn't say inverted. And earlier it does not say on, it says on. It says
The-
intervened. Anyway,
the house of Manoj Singh is half kilometer far from my house, and I do not know his uncle's name. I do not know whether there was any dispute between the deceased and the relative of Manoj Singh regarding family affairs.
where is Singh? There is no Singh.
I heard 11 things.
Before regarding family affairs, there is no Singh.
Worship.
And the relative of Manau regarding family affairs. So,
Or regarding family affairs. I
there is
heard
no
that the
Singh.
deceased sustained injury at his throat by fencing before about 7 days of occurrence. 7 days of occurrence. Worship. Before his death, 7 days, he has severe injured. And he received injury in his throat. Worship. But I do not know whether he received any treatment or not. It is called, it is
By
declared.
fencing meaning what? What do you mean by fencing? Fencing with swords? Or I don't understand. I think there's something to do maybe with the. But this is the original, I think. Sustained injury at his throat by fencing. What do you mean by fencing? Okay, then carry on.
It is not the fact that the injury which was sustained by the deceased was caused because of the extramarital affairs.
So this is only a suggestion, Mr. Counselor.
So Manoj Singh and their family, and he is also disputed. Manoj Singh and his family, there may be dispute worship. And
Manoj Singh and whose family?
this is not family.
Who is Manoj Singh?
Manoj Singh is his neighbor also, but he is not examined.
Why should he be examined?
Somebody, it is not in here, not even, some extramarital affairs in Manoj Singh's family and he and deceased And that's why he received before 1 week with severe injury and also due to it is not clear here, Lordship, but I know it.
Huh?
I go to the jail also, sir, Lordship.
So?
And contact the accused person. They tell me that like this is the.
So this Manoj Singh is a male or a female?
Manoj Singh is male, Lordship,
Male.
male.
So the deceased was having an extramarital affair with whom?
This Manoj Singh's sister, Lordship.
With Manoj Singh's sister.
Lordship.
Where is that?
It is not here, Lordship. It is just orally they tell me,
We cannot.
you will suppress this, they are innocent person is also lost in India.
So why should the innocent person be caught?
There are no any connection, no any. It's very clear, Lordship. And also they are distance is at least 3 kilometers from this home. That's why the Digimon
But then they saw
That's
you,
what
but
Digimon
then
saw.
they saw you running in the rain.
is.
What were you doing running in the rain?
They're saying it is a story, Lordship.
Sorry,
Story.
not true.
Not-
You were not there in the place of
Not
occurrence.
a story. It's very clear, Lordship. And that's why the Digimoni Sharma, he is Manipuri community. He understands their language.
Did the appellants know the deceased?
No, no.
Huh?
No,
They knew or they didn't know?
Lordship. No. No. This accused person does not know who is he. He is very small aged person, 36 years. He does not know. Also, Lordship, the SI Digimoni Sharma, who does not file the charge sheet, after 7 months, charge sheet was filed. Lordship. You know this very clearly.
Anything else?
And also his two father and mother also alive, Lordship, but they do not contest this case.
Father and mother of whom?
Oh, this is person. Lordship. They do not
Where is it required that they have to contest the case?
They do not really one-
Where is it required?
Usually they know the fact, that's why
Huh?
they know the fact clearly. It is not the fact, that's why he said, how can we?
And you know the facts better
I conflict,
because you go to the jail and talk to your clients. Correct.
but in findings also it is not there. Nothing against them.
Okay, that's all. Yes, ma'am. Any citations, anything? Nothing.
Citation is.
Yes.
The CBI versus Tapan Kumar Sinha, law,
Yes.
2003, 6 SFC.
Yes,
Here, Lordship, GT&T is not simple documentation. Page 15, Lordship,
page 15.
15. Para 15, Lordship.
Yes,
It is correctness is there, is the correctness of these findings, which is assailed before us by the appellant. They contend that the informant recorded the GT&T does disclose the commission of a cognizable offense. They submitted even if their contention that after recording GT&T, only primary inquiry was made is not accepted. They are still entitled to sustain in legality of the
you come to para 16. Why are you reading para 15?
question. Then Lordship, there are 23 and 24. Lordship.
You are reading the wrong para. Para 16 is the relevant para.
Oh, Lordship. GT&T may be treated as first information report. Lordship. That's why Nazrul Khan report is very vital. 9-5. Lordship.
Yes, so what else do you want? Which are the para 16, that's all.
Second, Lordship. Two thousand two, one SSC Lordship. Hari Chowdhury.
Yes,
It can be through FIR against same accused. The GT&T is seemed to be the first FIR and second FIR. First
where page, para?
para Lordship. 11 Lordship.
Huh?
Learned Council adopted an alternative contention that the ones of proceeding initiated the FIR numbers and that the final report. Police had no authority to register the second FIR. So, Lordship, in this, if GT&T is the first FIR, police has no second
Mr. Council, where does it say that GD entry has to be a first and has to be treated as the first FIR? It only says that it may be treated as a first FIR. It does not say that it has to be treated as a first FIR.
Also, Lordship. One is our High Court judgment, Lordship. Hare Krishna Das, versus State of Assam, Lordship. The contradictory statement 61 and 64. Lordship.
Where is the contradiction? I think that's enough. Yes, madam. Where have you come from? Let us hear the amicus.
Yes.
May it please your lordship.
Yes,
The date of incident is 29/7/14 at 9:30 PM. And the FIR was lodged on 30/7/14. It was registered as Lala PS case of Hailakandi, GR case number 1083 of 14. Under section 341, 342, 302 and 34 IPC. PW1, Karunakanto Sinha, he has lodged the first information report. But lordship will note from his evidence that he came to know from neighbor Dharmen Singh about the incident. And the alleged eyewitness is PW7, Lordship, whose evidence is that pages 9 to 10. Your Lordship will come to page. Korunakanta Sinha's deposition is at page 9 to 10, and at page 11, he deposes before the court that he came to know from Dharmen Singh, the neighbor, that while Dharmen Singh was coming from Kalasera towards his home after his arrival at village Rajagaon, he, Dharmen Singh, saw the accused, Putu Das, Raju Das, and Kalai Das assaulting his nephew, Harendra Sinha, by means of a sharp weapon. The accused persons are daily wage earners. I know the accused, the Raju Das, sustained fracture injury at his waist before the incident. 4 lines before the conclusion of that para at page 11. Lordship will take note that 1, 3, and 6 are in fact, their evidences are hearsay evidence. Although PW1 is a first informant, he has come to learn about the incident from someone from the gathered people. He has deposed that someone from the gathered people informed the
So how does it matter?
police.
It's hearsay, so leave it aside.
Yes, Lordship. And PW7 witnessed the incident with the flash of bike's light. It was a dark night, Lordship.
So
At 9:30 PM, the incident happened, and there was a heavy rainfall at that time. Your Lordship will get that from page 25, Lordship.
yes, so
It
there
was
was.
a
rain.
dark night.
So how
due
does
to-
it matter? It
I
is a
did
dark
not-
night in the flash with lights, you can see things. How does
Yes.
it matter?
It matters, Lordship,
How?
because the eyewitness has not seen the incident. It was raining, and in the darkness of dark hours, he may not have seen.
No, may not is a different thing. When he says that he has seen it, how do you say that he has not seen it? Why do we use torchlights at night?
And then he has seen. it.
Madam, I don't know whether you have used torchlights at night.
Yes, Lordship.
You have used torchlights at
Yes.
night. Have you used torchlights during the rain? At night? You have not. I have number of times, especially in the hills, we need to go here and there. So don't tell me that just because it's raining and it's night, with the torchlight, you can't see anything. That the purpose of a torchlight is that you are able to see in the dark. I've driven my vehicles when there is thick fog and that you can't see, but then you take out your head outside the side of the window and see the road, just to see the black road, that's all. So I mean, with lights, with a little bit of light, you go slower. It's possible, it's not impossible. The reason is that lights are required. And this is not a case where there's fog. It's a case of dark night, that's all. I don't know what's the logic. If it's dark night, the torchlight won't work. If it's raining, it won't work.
And then, my lord, at page 14, PW3, and then page 29, Nazrul Khan is named. And that Nazrul Khan is a material witness. He has not been examined, Lord. PW9 says that he received the information from Nazrul Khan. He has not been examined. Non-examination of material witness is fatal. And PW10, who is the IC of Lala Police Station, he did not visit the place of occurrence, and no evidence that the accused were apprehended. And PW10's evidence at page 31, we get to learn that it was based on the charge sheet. The accused Raju Das has been convicted. There is the judicial precedents have clarified, Lordship, the result of charge sheet is the result of investigation under section 173 CRPC. When the charge sheet is filed, it's the result of investigation, and the result of investigation cannot be made the basis of a conviction. And this was basically, in my humble and respectful submission, a case of lackadaisical investigation, lacking vitality and purpose. And as such, this accused person should be acquitted, Lordship. I have few judgments. which I would
Only
like
was
to-
too many. Give us only the relevant ones. No point giving us everyone is giving us the basic laws all the time.
First is Sarwan Singh, Ratan Singh.
How many
case, Lordship.
judgments are you giving us? Make it less. Don't give us a whole bunch. The same judgments we get in the same different,
Three lots.
different.
Just three of them. First is Sarwan Singh, Ratan Singh case, Lordship. The last paragraph, Lordship, I shall provide that to your Lordship's Lordship. Mr. Gopal Singh contended that considered as a whole, the prosecution story may be true, but between may be true and must be true, there is inevitably a long distance to travel, and whole of this distance must be covered by legal, reliable, and unimpeachable evidence. We have carefully considered all the arguments which Mr. Gopal Singh urged before us, but we do not think it would be possible to regard the approver as a reliable witness and hold that the confession of Sarwan Singh is voluntary or true. In the result, the appeal preferred by Sarwan Singh must be allowed. The order of conviction and sentence passed against him must be set aside, and he must be acquitted and deterred. And then Lordship, State of UP versus Jaggo, non-examination of material witness, Lordship. Para 14 and 15. It relies on Habib Muhammad's case, Lordship. And then lastly, Vijender versus State of Delhi, Lordship. Para 25,
So where is our
And-
copy?
para 11. I'm providing the copy. Thank you. And lastly, my lord, the burden of proof in a criminal case almost always rests on the prosecution. And this general burden can never shift.
Those are the normal.
In this case, the prosecution was bound to lead the best evidence, which has not been done. So my lord, this accused person should be acquitted.
What is this 1997 6 SEC? Para 11.
That's Vijender, lord.
Yes, which para do you want? In 1997.
Para 25, lord.
And
Para 19, 25, 33, 35, 37, and 38.
What about this 1957?
Yes, lordships, that's on the point that suspicion, however grave, cannot take the place of proof.
Which para?
Para 12, lordship. Where Gopal Singh's submission is recorded by the court. On the record.
That is always there. That's all.
Lord. And your lordship will take note that this has been a case of dishonest investigation and most of the witnesses are
Dishonest.
hearsay witness.
Dishonest.
Yes, lordship.
So are you alleging malafide?
Yes, sir.
Then have you made them a party? Name.
Prosecution was bound to lead the best evidence, which has not been done. in this case. That's all.
Yes, ma'am.
Lordship, as I have submitted earlier, whether your lordship will appreciate the evidence of PW7. If his evidence is reliable, then your lordship will uphold the conviction, overlooking the discrepancies, whether it is minor or it's a fatal one, your lordship. May I take your lordship to the evidence of PW7, my lord? Once
No,
again?
this before that,
Yes,
why wasn't this Nazrul Khan made a witness? He had gone and
yes,
given.
he's a vital witness, your lordship. Material witness to the prosecution, but he was not examined. I have checked the charge sheet also. He was not cited as a witness, your lordship.
Why?
It lapses on the part, your lordship,
Then
the prosecution.
What does that imply? Does
Lordship,
that imply that you're hiding something?
my lord.
Does that imply that you're hiding something?
No, but your lordship, if your lordship takes into account the GD entry, may I take your lordship to the GD entry, my lord, page 82, what Nazrul has seen, my lord. Page
See,
82, your
line.
lordship. May I read it once?
Yes.
Now Sri Nazrul Khan, my lord, page 82. Has your lordship got it, my lord?
They saw a person lying injured.
Yes, he only saw the injury part, but the eyewitness, my lord, PW7, he saw the accused person assaulting the deceased, my lord, in the torch, in the light of his motorcycle, your lordship. So, your lordship, I don't think, although it's a lordship, they could have examined, cited him as a witness, my lord, but he saw the injury part. He informed the police station about the injury, that the one person lying with an injury and that place, my lord. But PW7, lordship, he talks about the injury, he talks about the those accused persons were present at the place of occurrence, my lord. During the rain, it was raining, my lord. So I don't think it's
What
It's
about
better.
no recovery of weapon?
lordship, there are judgments of the Honorable Supreme Court as well as the High Court. It's not fatal, my lord. Non-recovery of the weapon. And your lordship considers the injury, if your lordship considers the post-mortem report, it cannot be only one person is given an injury. He received injury on chest is abnormal in your lordship, as a result of which he died, my lord. Nature of injuries, your lordship will take into
Okay, what
account.
about the fact that these persons were found in their houses?
No, lordship, may I take your lordship to the judgment, my lord? At judgment page 57, it starts, my lord. Page 63 is relevant portion. Only Raju was there at home. Lordship, page 63, third line. Accused Raju came out from his house and thereafter police along with Raju went to the house of accused Kutu. And on being called by Raju and police, Kutu came out. So he appeared.
Page
63.
63,
63 is a part of judgment, your lordship.
para.
Para, it starts from para 13, relevant portion at para, it's like end of para 13, my lord, page
Okay.
63, third line. Accused Raju came out from his house and thereafter police along with Raju went to the house of accused Kutu. And on being called by Raju and police, Kutu came out from his house. Thereafter, the accused Raju fled away. Raju absconded, but police took Kutu with them. Accused Kalai was not found in the house. There are 3 houses in between his residence, the residence of the deceased Harendra. One was absconding, one was caught, and the other one was not found, minor. Roshi?
Anything else?
I think evidence of PW 7 coupled with the postmortem report, your lordship. Sufficient, my lord, to convict, my lord. Although there are discrepancies, non-recording the evidence of this one, the person who,
Okay, where is the judgment regarding that non-recovery of the weapon?
lordship. I'll give you lordship, I have. 2013-12, this is another 2013-12 SCC 796. This is. Lordship, I'm sorry, I have got only one copy. 2013-12 SCC 796, your lordship. Para 33 to 37.
Okay.
Para 33, your lordship. The learned counsel for the respondent has urged before us that there has been no recovery weapon from the accused, hence the prosecution case deserves to be thrown overboard, and therefore the judgment of acquittal does not warrant interference. In Lakshmi versus State of UP, this court has ruled that undoubtedly the identification of the body, cause of death, and recovery of weapon with which the injury may have been inflicted on the deceased are some of the important factors to be established by the prosecution in an ordinary given case to bring home the charge of offense under section 302 IPC. This, however, is not an inflexible rule. It cannot be held as a general and broad proposition of law that where these aspects are not established, it would be fatal to the case of the prosecution. And in all cases and eventualities, it ought to result in the acquittal of those who may be charged the offense of murder. 13-12 SCC 796. Lordship, then para 35. In Lakshan Sao versus State of Bihar, it has been opined that the non-recovery of the pistol or spent cartridge does not detract from the case of the prosecution where the direct evidence is acceptable.
The first para was which one was the para?
Para 33 to 37, your lordship. This was in my report.
But one thing is,
My lord.
if Dharmen Singha did not see how, did not see what weapon was being used for assaulting the deceased.
No. They did not see. But he saw, I have checked 161 statement also. He saw the accused person in the crime scene, your lordship. They were assaulting the deceased. So it attracts section 34.
So
Vicarious
what
liability.
what did the police do to try to recover the weapon?
Lordship, may I check the evidence of IO, your lordship? PW 9 and 10, you know. Lordship, may I read the evidence of IOA page 31? These accused persons are apprehending, Your Lordship, apprehending arrest, if Your Lordship considers page 31, the evidence of PW 10. Prior to that evidence of PW 9, if I can extract something, my lord. May I read it, my lord? Page 28. I'm sorry, Your Lordship, page 28, Your Lordship, can you have a look?
Yes.
On 29/7/14, I was posted at Kalachera OP under Lala PS in charge, SI of police. On that day at about 9:05 PM, one Nazrul Khan appeared in the OP and informed me that one person was lying on the ground in injured condition at Razargaon by the side of the road. Then I made GD entry number so-and-so, is the exit copy of so-and-so. Thereafter, I along with the staff went to the PO and found Horrendra Singh lying on the road, namely Golachera Road with grievous injuries in unconscious state. Immediately, I arranged for 108 ambulance and shifted him to SK Civil Hospital, Hailakandi. It was heavy raining on that relevant night. I prepared a rough sketchmate of the place of occurrence by so-and-so. I seized one pair of plastic sandal of black color, also seized one piece of Burmese sandal or left foot, one torchlight, 2 numbers of battery, one black color inner Genji by so-and-so. The material exhibit is being seen in the court. I recorded the statement of witnesses. On the night itself, I apprehended the accused Kutudas from his house, but I did not find the other accused person. The accused Kutudas was medically examined on 29/7/14, and the doctor found one abrasion injury 2 centimeters to so-and-so on live zygonalic area. Thereafter, I arrested him and forwarded him to court. On the next day, that is on 37/14/1, Karunakanto Singha lost an FIR from which I came to know that the injured succumbed and thereafter the postmortem was performed in the dead body. The FIR was registered in so-and-so. Then Lordship, he handed over the case to OC Lala PS. After receiving the information from so-and-so, I went to PO 910. I did not examine Nazrul. From the GD entry, I did not find any information regarding presence of other person in the PO. From OP to reach the PO, it takes 5 to 7 minutes. In the case diary, there is no note in regard to the fact that when I arrived at the PO, I found any other person there or not. Police person, namely Mihir Kanti Singha, Motiur Rahman and Sopan Kumar Nath were with me. In the FIR, the time of occurrence is mentioned as 9:30 PM. The sandal which was seized definitely there would have footprints. The torch which was seized is generally being used by hands, and as such, there is every possibility of having fingerprints, but due to rain, it was washed. I did not take any step to send the seized material for FSL analysis for comprising footprints and fingerprints. I also did not make any effort to assign the owner of the seized inner Genji. The time of seizure is not mentioned in the seizure list. Apart from police person, I have not made any other person in seizure witness. The nearby people as shown in the sketch note, so were not examined in connection with the case. In the case diary, there is no note as regards whether the injured was naked or was worn by clothes. I did not seize any bloodstained cloth. On the relevant night itself, the PO, I recorded a statement of 6 numbers of witnesses. I have not noted down the time of recording the statement. I did not seize any motorcycle. I did not find a motorcycle so-and-so in the relevant night. I, along with 3 staffs and 1 Dharmendra, went to the place of Kala Pahar, and at that time it was heavy raining. At first, we went to the house of Raju and then to the house of Kutu. Dharmendra was accompanied us. I did not make any effort to inquire. So at 2 o'clock, you know.
One thing, okay. What was the motive for killing? Any motive?
Motive, Lordship. I did not find it. It will come on record.
Just like that.
May not be, I have to judgment, not always, it's a important aspect. But when direct evidence is there, your Lordship, motive may not be integral part.
You-
Para 15 to 24.
Para 15?
To 24. Para 15, Lordship.
Only one book. Huh?
Only one book.
Please read it.
Lordship, I'll read slowly. The legal position regarding proof of motive as an essential requirement for bringing home the guilt of the accused is fairly well settled by a long line of decisions of this court. These decisions have made a clear distinction between cases where the prosecution relies upon circumstantial evidence on the one hand and those where it relies upon the testimony of eyewitnesses on the other. In the former category of cases, proof of motive is given the importance it deserves. For proof of a motive itself constitute a link in the chain of circumstances upon which the prosecution may rely. Proof of motive, however, recedes into the background in cases where the prosecution relies upon an eyewitness account of the occurrence. That is because if the court, upon a proper appraisal of the deposition of the eyewitnesses, comes to the conclusion that the version given by them is credible, absence of evidence to prove the motive is rendered inconsequential. Conversely, even if the prosecution succeeds in establishing a strong motive for the commission of the offense, but the evidence of the eyewitnesses is found unreliable or unworthy of credit, existence of motive does not by itself provide a safe basis for convicting the accused. That does not, however, mean that proof of motive, even in a case which is raised on an eyewitness account, does not lend strength to the prosecution case or fortify the court in its ultimate conclusion. Proof of motive in such a situation certainly helps the prosecution and supports the eyewitnesses. See Shivaji versus so-and-so, Lordship, the para 16. The case at hand raised upon the deposition of the eyewitnesses to the occurrence. Absence of motive would not therefore by itself make any material difference. But if a motive is indeed proved, it will lend support to the prosecution version. The question is whether the prosecution has established any such motive to fortify its search against the appellants. When there are discussions are made, Your Lordship, para 17 onwards. Then, my lord. In our case, Your Lordship, other Lordship discussions of the cases given, Your Lordship. I think para 15, 16 is sufficient, Your Lordship. In our case, Lordship, evidence of eyewitness is sufficient, Your Lordship. There is nothing to disbelieve his evidence, Your Lordship. May I cite one more decision on motive, my lord? 1996, 10 SCC 615.
Yes.
Para 9, my lord. We may deal with yet another submission of Sri Bachchan, which relates to the entire failure of the prosecution to bring on record any motive for the assaults. There are two answers to this submission. The first is that motive lies locked in the heart of a man, and so it becomes difficult to know the same. Failure to bring on record any evidence regarding motive does not, however, weaken a prosecution case, though existence of the same may strengthen the same. Secondly, there is also nothing on record to show as to why the dying man would have. Their dying declarations are there, Your Lordship, in the instant.
And the declaration is different.
Well, that the case is different. Lordship, then one judgment on testimony of a single witness. Testimony of a single witness. 2014, 2 SCC 455. Para 21. The legal system has laid emphasis on value, weight, and quality of evidence rather than on quantity.
Yes.
Multiplicity or plurality of witnesses. It is not the number of witnesses, but quality of their evidence, which is important, as there is no requirement under the law of evidence that any particular number of witnesses is to be examined to prove, disprove a fact. The evidence must be weighed and not counted. It is quality and not quantity which determines the adequacy of evidence as has been provided under section 134 of the Evidence Act. As a general rule, the court can and may act on the testimony of a single witness provided he is wholly reliable. Well, there are defect is there, non-seizing of material particulars and motorcycle is not it was not used as a weapon of crime, your lordship, then it is, I don't think it's material, my lord. I think the prosecution could prove, if your lordship relies on the evidence of PW7, my lord. So those persons,
Was any question put to the
witnesses, my
to
lord,
the appellants
my lord, may I check?
as to where the weapon was
Yes,
by the IO?
but IO doesn't say so.
You
my
see,
lord.
when you interrogate some person,
Yes,
then it's natural that you should ask where is the weapon.
yes, my lord. May I check, my lord? But it's not a lordship, if a lordship relies on the evidence of IO, my lord, he doesn't say so that he seized. So,
Someone must have seized, then who seized?
yes, my lord, it was not seized, my lord.
If it was not seized, why was it not seized? Was there
It's a
a
lapse, my lord.
search made for it?
Nothing, my lord, I didn't find anything, my lord. Regarding the seizure.
You see, there is another thing.
My lord.
On the fateful night, it was raining. And if it was raining and was dark, he should have been close to really look at their face with the light. Now, there is nothing in this evidence which states that he saw the appellants assaulting the deceased with a knife or any weapon.
No. That is not, they have checked 161 statement also. He says, my lord, may I read it once? It's a vernacular. That aspect I have looked into, your lordship. He saw, my lord, it's written as follows. আমার মোটর সাইকেলের লাইটৰ দ্বাৰা দেখিতে পায়ে রাজারগাঁও পিডব্লিউডি রাস্তার মধ্যে কয়েকজন লোকের মধ্যে মারপিট হয়েছে। Then আমি নিজ চক্ষে কুটু দাস, রাজু দাস ও কালাই দাসকে দেখাইয়া যাওয়াতে দেখি সম্পূর্ণ সত্য। He saw the accused person, but regarding the weapon use, I don't find anything. Marpit, he talks about a marpit, but he doesn't talk about the weapon of assault, that he was like, they were assaulting him with a murder weapon, nothing. But Loshi, I found one judgment. It's a what they were doing in the during hours that it was raining. There's no explanation from their side. What judgment is there? Please vary from the. Okay.
In the 313, what have they stated?
Nothing.
They have denied.
Mm.
Complete denial.
Yes, complete denial. Loshi, 2011 8 SCC 80. बस और पर किताब नहीं तो सब कौन है
2000.
11 8 SCC 80. Here the murder was committed during the dead hours of night. Owner shifted to the defense to explain. State of UP versus Muhammad Ikram Sassoon.
Para.
There are 26 in my diary. I have to check the Loshi. They owe an explanation under section 106. I said, page 80. Side in minimum.
The present case was in between 9:05 to 9:30.
But it was raining. Generally, the people don't come out during that hours, your lordship. And it was, which month may I check? Date of occurrence is July 29/7. Yeah, 39. So state of UP versus Muhammad Ikram. There are 26. My diary says, no, I have not checked.
That 26. So the problem is,
My lord.
why would PW7 give
Yes.
his evidence to the detriment of the appellant?
Yes. There's no enmity, my lord.
Any reason, any suggestion as to why he should have given such a eyewitness account?
May.
You see some bad blood between the
Yes.
persons, some family dispute, something or the other, some land dispute or anything. Otherwise, why should somebody just blame somebody just like that?
Lordship, one question, page 24. Though I have in cross states, though I have prior introduction, some, I don't know, introduction with the accused person, we have no visiting terms with them. But regarding enmity, it's not there, I know.
Visiting terms is neither here nor. there.
Yes, my lord.
It just means that they don't meet each other.
Yes,
They don't know each other. or-
yes. It's not the defense case, my lord, that they had some enmity, they were falsely implicated.
PW1 and PW6 also stated, I never heard and noticed any dispute between the
Okay.
accused person and DCS. 1 and 6.
It goes against you. They are supporting
gives
the
handle to that.
prosecution.
Prosecution
I
case.
never heard.
So that is what, you see, if you could show otherwise, then it would have been in your favor. But now you have just shown that there is nothing against that PW7 which would have made him give such a kind of evidence against you. Anybody else is there? I saw,
Informant is there.
yes. Anything, Mr. Counsel? Nothing to add.
Item number 6, and while this matter was going on,
Please, I cannot hear. We cannot hear. Yes,
in item number 5, my lord, that is the jail appeal, I am representing the informant. And in item number 6, my learned friend, my senior friend is representing the informant because he was not well at that time, so I was engaged in the jail appeal. Lord, nothing to add, my lord, only to supplement what my learned senior friend has argued, my lord, before my lord. If my lord comes to page 67 of the paper book, my lord, paragraph 21.
yes,
And if my lord comes to 68. If I may read, my lord,
yes.
in cross-examination, this is regarding PW7. In cross-examination, he made it clear that at about 9:10 PM, he went to Kalasara market for purchasing medicine, and while he was going to the market, he saw all the 3 accused persons were coming from the market side. He has further stated that at the time, it was heavy raining, and due to the rain and darkness, there was no person on the road. During examination of the accused person under section 313 of the CRPC, they have not mentioned anything about their any enmity with the PW7. Further, there is no material on record suggesting that there was any enmity between PW7 and the accused person, prompting PW7 to implicate the accused person falsely. So what has fallen rightly from my lord, and it has been justified in this judgment by the learned trial court. There is nothing to that why the PW7 will implicate these 3 persons. And my lord, to add, my lord, 2 judgments were relied upon by the learned trial court, my lord. One is regarding motive and one is regarding the subtle principle that sole eyewitness can also lead to the conviction of the accused person. May I give the judgments, my lord?
Which one?
Relied upon by the learned trial court, my lord.
No, how does it matter? With regard to motive,
Yes, my lord.
same thing.
Same. And only that aspect, my lord. Nothing to add. Senior counsel has touched all the points, my lord. So, my lord, we pray that, my lord, the conviction may be upheld, my lord. Because, my lord, 36-year-old person has been, my lord, killed, whichever way it may be. Obliged, my lord.
Also, whether compensation will be awarded to the victims, sorry. Any compensation has been given in the judgment of the chair?
We don't know.
My lord, it's generally reflected in the judgment.
Yes.
Yes, recommendation is
Correct.
given, yes.
Okay. We'll. Heard, Mr.
A.H. Alamgir.
A. Talukdar,
A.H. Alamgir.
A. H. Alamgir, learned counsel for the appellants. There are two appeals, is it? Appellants. And you are the legal aid counsel in which? In both the cases?
Item 5. Raju Das.
103.
In both the cases, and Miss
Bernali Chaudhary.
Barnali Chaudhary, learned amicus
Yes.
curiae in criminal appeal J 103/2019. Also heard Ms. B. Boyan, learned additional PP SM, comma, Mr.
NH Majar.
NH Mazar Boyan, learned counsel for the informant. Acha, you both of you are there. Mr. MH Mazhar. Okay, Mr. NH Bazar Boyan and Mr. Huh? Okay, for the respondents, you got them. I think we'll call him. Almost. Call Nilakhi. Okay, you're right. Heard Mr. A. H. Alamgir, learned counsel for the appellants. comma, Miss Barnali Chaudhary, learned amicus curiae, comma, Miss B. Boyan, learned additional PPSM, comma, Mr. NH Mazar Boyan, and Mr. for the informants, for the informant. The two appeals have been filed against the judgment dated 16/5/2009, impugned judgment dated 16/5/2019, passed by the Court of the Sessions Judge, Hailakandi, in Sessions Case number 19/2017, by which the three appellants have been convicted under section 341/302/34 IPC. For the offense of committing wrongful restraint and murder of the deceased Harendra Singha. The appellants have been, the three appellants have been sentenced for life with a fine of rupees 2,000 each. In default. No. To pay 2,000 each. In default, 2 months RI under section 302/34 IPC. They were also sentenced to undergo simple imprisonment for 1 month under section 341/34 IPC. The sentences are to run concurrently. The prosecution case in brief is that on 30/7/2014, the informant, who is PW1, lodged an FIR dated 30/7/2014 with the OC Lala PS, Lala Police Station, alleging inter alia that on 29/7/2014 at about 9:30 PM, his neighbor Dharmen Singha saw the appellants causing grievous, saw the appellants assaulting the deceased with sharp weapons on several parts of his body and left him on the road. Dharmen Singha bracket PW7 stopped his motorcycle and tried to catch the appellants. Appellants, who had however fled away from the place of occurrence. Full stop. Though PW7 chased the appellants, the appellants managed to run away. Full stop. An ambulance service was informed and the body of the deceased was taken to the hospital where he was declared dead. Full stop. On receipt of the FIR, Lala PS case number 223/2014 was registered under section 341/342/302/34 IPC. Full stop. After the investigation was completed by the police, charge sheet was submitted against the appellants, wherein the IO had found a prima facie case against the appellants under sections 341, 342, 302, 34 IPC. Listen. Next para. On (23/3/2017), charges were framed against the appellants under section 341/34 and 302/34 IPC, to which the appellants pleaded not guilty and claimed to be tried. Full stop. Next one. No, continue. During the trial proceedings, 11 prosecution witnesses were examined by the trial court. Examination of the appellants under section 313 CRPC was thereafter undertaken. Full stop. After hearing the appellants, the learner trial passed the impugned judgment dated 16/5/2019 in sessions case number 19/2007, convicting and sentencing the appellants. Full stop. Next para. The counsel for the appellants and the learned amicus curiae submit that the impugned judgment is not sustainable. Inasmuch as there is what have I said?
The counsel for the appellants and the learned amicus curiae has submitted that the impugned judgment is not sustainable in as much as there
Inasmuch
is
as there is contradiction in the time of the incident and the recording and the communication of the incident to the police. So they submit that. While the eyewitness PW7 had seen the incident of assault at around 9:30 PM on (29/7/2014). As per the FIR, and the evidence of PW7, comma, the GD entry number 476 dated 29/7/2014, made on the basis of the information provided by one Shri Najrul Khan, Najrul, Najrul Khan, showed that the GD entry had been made at 9:05 PM on 29/7/2014. The the learned counsels for the appellant also submit that in the statement made by PW3 to the police under section 161 CRPC, PW7 saw the appellants running away from the place of occurrence. However, in his deposition, in the deposition of PW3, before the learned trial court, comma, PW7 had told PW3 that the appellant had assaulted the deceased and fled away. Correct. That is what we are saying. See, when I'm dictating, how I am dictating in front of you with regard to facts, is that if I make a mistake and do not give my dictation as per what you had stated, you can correct me. So please listen to what I'm saying.
PW3 stated in
161.
PW7 is just said in that time.
They were running away.
Running.
But in the
Not accept-
evidence, he said that Dharmendra Singh said that he was being assaulted.
Sorry.
They were assaulting and then ran away. Correct.
In front of, in cross, he said. That is 161 and 64 it is. contradictory.
So that is what, so the difference is in 161, he did not talk about assault. In the evidence, he talked about assault, correct? So I have not made a mistake, that means. So stop. Next para. The learned counsel for the appellant submits that though PW7 had seen the assault, had allegedly seen the assault of the deceased by the appellants, on the basis of the headlight of his motorcycle, comma, the motorcycle had not been seized by the police. Though articles such as sandals, comma, torchlight, and a black T-shirt, which were lying on the place of occurrence, were seized by the police. So what happens if it is not seized by the motorcycle? If they do not seize the motorcycle, what is the effect of the same?
Question is that in the criminal proceeding, whatever is used, it may be.
It was
before-
not used, it was just seeing it.
It may be before court. Lord.
Supposing in the darkness at night, in a building, in a room, at night, the witness turns on the light and sees them and sees the incident of assault, say inside the room. When the police come, will they also see the tube light? No, this is the light which you saw the incident. Will this, is it required? Just asking you,
But Lordship,
how will it help?
if T-shirt and chappal, sandal, Lordship, also it is not matched with the accused. Lordship. If it is not, everybody has some size, 34, 36, if it is matched this, also it may be from there.
I-
It is also not.
But I'm not understanding the logic behind the motorcycle. I'm not talking about sandal and anything. I'm not on that. You said that this motorcycle was not seized.
Maybe
What is
motorcycle.
the logic? If it was seized, what will happen?
Question is
What
that-
will they use it for? Oh, so this was the motorbike headlight or what?
But the question is that if maybe motorcycle or not maybe motorcycle.
Huh?
If he may be lying in that time, Lordship. It is motorcycle, but in existence there is no motorcycle. That's why
There-
it was seized.
Did you say, did you confront the
yes.
witness? Did you confront the witness in your cross-examination
Lordship,
that there was no motorcycle?
Though it is not seized or recovered, that's why you can imagine.
Okay, next. The learned counsels for the appellant and the learned amicus curiae submit that though the medical report of the doctor shows that there were stab wounds on the deceased, comma, no weapon had been seized or recovered by the police to prove that any weapon had been used by the appellants while allegedly assaulting the deceased. First up. They also submit that the GD entry having been made at 9:05 PM on 29/7/2014, comma, that is before the registration of the FIR, no, the filing of the FIR, comma. The person who gave the information for registering the GD entry had not been made a prosecution witness nor was he examined. By the court. Full stop. They accordingly submit that Shri Nazrul Nazrul Khan, being a material witness, comma, the non-examination of a material witness was fatal to the case of the prosecution. Full stop. They also submit that the evidence of PW 1, 3, and 6 was hearsay evidence and could not be the basis of coming to a finding of guilt against the appellants. Full stop. That's all I think. Full stop. Now you want me to refer to your judgments? In support of their submissions, that the impugned judgment should be set aside due to the reasons mentioned in the foregoing paragraphs, comma. The councils have relied upon the judgments of the apex court in number 1, Superintendent of Police, comma, CBI and others versus Tapan Kumar Singh. 2003, 6 SCC 175. And bracket you just write para 16, comma 20. Huh? Then why have I got so many? I don't need. You have relied upon,
Regarding-
no, wait, huh?
regarding the
Yeah,
FIR,
CBI versus Tapan Kumar Singh. Then next one,
Tariq Chaudhary versus Chika Devi. 2002 SSC.
which para?
Kari Chaudhary, KARI.
Para. Para 11.
Two 2002-1 SSC.
Which paragraph?
Paragraph is 11. There cannot be two FIR against the same accused in respect of same case.
Right. Kari Chaudhary, KARI, huh? Versus MST, full stop, Sita Devi and others. 2002, 1 SEC 714. bracket para 11. Anything else? That's all I think.
And another is Jagat Singh and state of Punjab. The benefit of doubt.
It's not relevant. Then number 3 will be, madam, you had gone for, which are the cases?
Sarwan Singh Ratan.
Sarwan Singh. Para?
Para 12.
Para 12. Sarwan Singh, son of Senso versus state of Punjab. AIR 1957, SC 637. No, out here, they have not said anything.
Last para.
Huh?
Relying on Gopal Singh.
Huh?
Relying on Gopal Singh submission.
So what have they said? Please read it carefully. There are other judgments. Out here it has not been, it has not been decided as such. They are only mentioning his submissions, that's all.
Yes, Lordship, that there is a long line of distance between what is may be true and must be true. That part I mean.
But where are those decisions? This decision does not, this decision only mentions about his submission. No, cut that. There are decisions, I know. There are a lot of decisions. Yeah, you are going backwards. You should come forward. The decisions passed in the last 10 years. Enough decisions. Cut that number 3. The next will be Vijender versus State of Delhi. 1997, 6 SCC 171. Para. Nineteen and 25, huh? Then next will be State of UP and another versus Jago Alliance. This is 1971 2 SCC 42. Para. $15. Okay. This one judgment I was looking for. Acha, in that CBI case, na? Para, oh, that's one. 16 and 20. No? Okay, next. The learned addition PP. Sam. And the counsels for the informant, on the other hand, submit. that the submit that minor inconsistencies in the evidence of the witnesses which does not go to the core of the prosecution case. Can be ignored. Full stop. They also submit that no prejudice was caused to the appellant just because the motorcycle was not seized by the police. Full stop. They also submit that though the entire case is based on the testimony of the sole witness, comma, that is PW7, comma. The learned trial court has rightly laid emphasis on the value and quality of the evidence of PW7. Full stop. They accordingly submit that conviction can be based on the basis of the sole testimony of on the testimony of a sole witness, sole eyewitness. And in this regard, they have relied upon the judgment of the apex court in Veer Singh and others versus State of Uttar Pradesh, 2014, 2 SCC 455. Yes, you have to. Yes, where were we? 2014.
2014 2 SCC 455.
Okay, next para. The learned counsels for the, no, the learned additional PP also submits that when there is an eyewitness account of a crime, comma, the importance of motive recedes into the background. And in support of a submission, comma, she has relied upon the judgment of the apex court in Dash versus Dash, reported in 2011, 3 SCC 654. So, What is this 2013-12? It pertains to
2013-12.
wonderful.
Yes,
Uh, yes, which para?
there are 34. May I see, check it up once.
She also submits. That
There are 33 and 34, ma'am.
the non-recovery of the weapon of offense is not fatal to the case of the prosecution. As there is direct evidence of the appellants having assaulted the deceased. Full stop. In this aspect of the matter, she has relied upon the judgment of the apex court in Dash versus Dash, comma, 2013-12 SEC 796,
746, ma'am.
para 33-34,
746.
746. He also submits that where is this 2011 8 SEC? No. This is 2011 8. Is it that one? Is it that? She also sub 8, 2011 8. She also submits that in terms of the judgment of the apex court in Dash versus Dash, as reported in 2011 8 SEC 80. Bracket para 26. Comma, once the prosecution had brought home the evidence of the presence of the accused at the scene of the crime, comma, then the onus shifted on the defense to have brought forth suggestions as to what could have brought them to the spot, no, to the place of occurrence in the dead of night. Full stop. As no explanation has been given by the appellants during their examination under section 313 CRPC with regard to why they were present at the spot, comma, the prosecution had proved the case of assault on the deceased by the appellants. They learn it, that's all I think.
Regarding
Anything?
enmity part, my lord,
stop.
enmity, they have
Okay.
prior enmity.
Okay, she also submits. Now, the next para, the learned counsel, the learned additional PP and the counsel for the informant. Counsels for the informant. Submit. That. There is nothing on record to show. That there was any enmity. Between the appellants and PW7. Which would have explained. No, which would have. Given reason. For PW7 to have made a testimony. Against the appellants. This has also been clearly spelled out. By the learned trial court. In para 21. Of the impugned judgment. The additional PP and learned counsel for the respondent thus submit that no grounds for interference with the impugned judgment has been made out. And the appeal should be dismissed.
No,
We have-
sorry. Regarding non-examination of Nazrul,
Ah,
in the GD entry, he has only talked about injury.
okay, one more before that, huh? They say. And they also submit that. The non-examination of Shri Nazrul Khan. On whose information. The GD entry had been registered. Does not cause any prejudice to the case of the appellants. Inasmuch as he had only informed the police. With regard to. An injured person lying on the road. As such. There was nothing material. Besides the above fact that could have been stated. By. The said Shri Nazrul Khan. That's all.
Time is,
Lordship and
time is.
I've mentioned the time. I mentioned it. Your first point. 9.05 and 9:30, I mentioned it. We have heard the learned counsels for the parties. Yes,
one more aspect.
one more. Okay,
Regarding the presence of accused person at the scene of crime. And so they are jointly liable, your lordship. They were seen assaulting the deceased. Although murder weapon was not assault, so 34, it is attractive section 34.
so that then they are not, okay. You also say. And they just submit that as the eyewitness had clearly identified all the three appellants assaulting the deceased, comma. There was no infirmity in convicting the appellants under section 304/34 and 201. 301,
384 something like 384, 341.
341/34. Is there any more matter? Okay, then we'll keep it CAV, we'll keep this CAV then. Well, then we can, since he's been waiting whole day.
This morning when I'm waiting, but my matter has been listed before other courts as much as 7 times earlier.
Ah.
And I argued the matter, but it was not completed.
You argued the matter but not complete.
Not complete, it has been left half done like this.
No, you see, that means there is only one thing, you are never completing your argument.
So, my lord, today.
So it
half an hour
depends.
Half an hour remains, my lord.
Okay, how long will you take to complete?
I will take it very shortly, my lord, within 10 minutes I'll conclude.
10 minutes, okay,
Within 10 minutes I'll conclude.
okay, very good.
And my line at Titi, how much she will take, I don't know.
No, she will take not more than 10 minutes, 15 minutes.
So my case, my lord, before starting the history of the case, my lord, I like to, before going to the record, I like to describe the brief history of the case so that your lordship will understand very quickly. My lord, the happening happened in the year 1996. 1996.
This is the 302 matter or?
302 matter, ultimately it was 436, 302, 447, 448, 449.
And 149.
149, 148, 149, 147. Like. So, my lord, the happening happened in the year 1996. So,
Take this one.
there was a fight between two groups, one is Munde, another is Horizon.
147, 148, 149, 302.
302, 302, 436.
436.
My lord. So, my lord, what happened actually when the accident was happened, there was no judicial court.
What accident? What accident?
Accident, there was a fighting between two groups of people.
Fight cannot be an accident.
No accident, my lord.
Huh?
It was a fighting two ethnic groups.
So a fight cannot be an accident. A fight is purposely done.
Yes, my lord. My lord.
Accident, when you say accident, it can be either vehicular accident or an accident, accidental fight, like
My
you said. But then this is not, a fight cannot be an accidental.
It is not an accident, my lord. Fighting, but accident. My lord, so
Lordship, in 10 minutes, he cannot complete, and I also might need some more time. We'll try, your lordship. Because 149 is there. And weakness is like.
When
there
the
are
it's 149, yes.
number of weaknesses. Accused person.
Where's the, yeah, okay. I got it. Just a minute. 340, 436.
Remedy number accused person.
How many accused are there?
17.
7
One
0,
was granted benefit of juvenility.
7 0,
Putoro, 17.
1 7.
17 no? Putoroটা আছে না?
My lord, actually the FIR indicates there are as much as 45 people's FIR say that in complaint it is stated that as much as more than 45 persons get out my house and set fire and burned into ashes. And when we supposed to came out, opposite party, that is the appellants, shoot them the both arrow to them, and one has been succumbed injury, and after was he lost his last breath, he died. This was the case, my lord. So it was the happening of 1996. The FIR said that there are as much as more than 45 persons who are gathered at my house. Thereafter,
Are you in jail?
I am in jail for last 3 years, my lord. I am in prison for last more than 3 years. So now, my lord, more than 45 persons, FIR said more than 45 persons get out my house. Thereafter, the case has been charge sheeted against 18 persons. Out of 18 persons, my lord, only 13 persons were tried, was initially faced the trial, and rest 6 were absconded. And out of 13 persons, one died. The trial has been made against 12 persons, and 12 persons has been has been convicted for life. 12 persons have been convicted for life. So, my lord, the case is this. It is surprisingly how those all persons have been convicted in the same amount of punishment, my lord, since there is no 34 sections in the case. Since there is no common intention, it is 149. So might be everyone has not shoot the arrow on the stomach of the deceased. Only one person might have shoot him. How 11 persons togetherly have been imprisoned for life, and therefore for last 5 years in prison. This is a case before the lordship. Now, my lord, I will go to the record. This is
How
the
long?
case.
You have already taken 5 minutes. Another 5 minutes you take. to the-
My lord, shortly I will be very shortly. Short time I will just one by one I will finish my argument, my lord. This is a case before lordship.
No, you see, one thing is this, you see, we have got no qualms of finishing the case.
My lord.
The problem is whether you will be able to do justice to your clients within 5 minutes or 10 minutes or 15 minutes. And that's all. You see, it's not that we are running away from a case, but then you might not be able to complete. That is what we are slightly worried with.
My lord. So, my lord, let us do one thing, my lord. Your lawsuit suggests me that on one Thursday, my lord, as fast I can make the art. Last 3 years, my lord, the appeal is pending and they are in prison.
Only 3 years. These persons have been in jail for since 2004. So tomorrow's matter we are going to hear.
My lord, my case is,
Yours is only 2020.
my case is very different, my lord. 11 persons, my lord.
So what? In that there are also few persons.
11
Six.
persons, my lord. My lord, on Thursday, my lord, has fast taken the kind of the art. On Thursday, one.
We have got on this, Mr. Constable. You cannot jump the queue.
Kindly.
If you can finish, huh? What matter? What?
One thing is, in our case, PW7, how much he is reliable? That's it. When 161 statement, he said he is a poultry farmer.
He
He is a poultry farmer.
is a political
Poultry farmer. Poultry farmer.
poultry farm.
Farm.
He's got a poultry farm.
Farmer. But lordship, in evidence, lordship, he said employee of Samsung company.
Ah.
So lordship, he is not reliable. He's in village is called Paka. Each and everybody know he is a Paka. Gunda Paki. That's why how much he is reliable and for how much we can take about. Is the question. 64 statement is clearly written. আমার নাম ঠিকানা উপযুক্ত মতে দিলাম আমার বয়স অনুমান 33-32 বছর আমি মুরগি ফার্ম করি
I'll tell you what we'll do. We'll maybe give you another chance. You cannot barge in like this while another case is going on. This is not a fish market. Hey, you give me for 40 rupees. Hey, you give me for 20. You cannot jump in. This is not an auction or whatever.
That's already statement.
It's a different case, Mr. Counsel, that we're dealing with. You have finished your arguments.
Judgment is also court tell me if it is wrong, tell me something.
We can think of maybe putting it in to be spoken some other day.
If wrong, that
Since we have kept it CAV already, We can say it to be spoken. Or we can put it as part 100, we'll see. He wants, he's scared.
161 and their substantive evidence period is there, your lordship, date of occurrence and date of giving substantive evidence. So like, in the meantime, he might have changed his profession. Regarding the
have, you know.
profession he's talking about.
Yeah, I know. Could have changed, we don't.
No, I'm not very precise.
He had a chicken farm earlier, poultry farm.
No,
Then now he has,
no. I am, in that time, he stated in police,
huh,
161 statement.
what did he say?
আমি পোল্ট্রি ফার্ম করি
Poultry farm. Then during evidence,
and in evidence it said employee of Samsung company.
Samsung. Chicken farm might have, he might have made a loss. There's so many persons.
It will keep on to be.
You see, I'll tell you.
From that kind
There,
of.
there is a friend of mine. He had 400 pigs in his pig farm. He took loan and all started. One fine day, African swine fever came. Gone, gone. Then he waited for around 7, 8 months. And the 9th month, he started again. Somehow, he had, I think, 170 pigs. Again, that swine fever came. Gone. Now he's given up. Sometimes it happens. And chicken, they also have, they die at one go sometimes. And it happens.
Question is that That kind of-
This, why didn't you confront the witness during that time? This is the time to to bring up this issue. And can't a person change his profession or his work? He can be a farmer one day, he can be a very rich person the next day. You see all these farmers in North India, after the land was acquired, all of them, I believe some of them having huge, big cars, driving very fast here and there, their children are enjoying life. So it happens. What is that? One day you can be a fish farmer, chicken farmer,
profession change
or what, poultry, you can have, you can have so many, you can have fruit trees one day, next day you might sell it off, do something else. How does that change anything? Do you?
So, my lord, my case, my lord, very shortly, shall I dictate the PWDs, but the same PWD,
These 11 persons, they were convicted,
my lord.
12 persons, because some person was killed with with an arrow. Is it?
Yes, yes.
Because one person was killed with an arrow.
Evidence is only one person. Evidence mentioned the name of only one person.
Then,
One evidence mentioned the name of only one person. And the rest other evidence, no any evidence. has been-
What does the trial
No
court,
eyewitness.
what does the trial court say?
Trial courts, my lord, ultimately trial courts concluded that everyone has come with a common intention to kill somebody or to destroy anything. So common guilt is there. So commonly he has given punishment for life to everybody, my lord. To everybody. So my lord, it's a very interesting case, my lord. Kindly see the PWDs, my lord, 11 PWDs. And all statements of the PWDs are almost same. All are hearsay. My lord, kindly have a look at, my lord, FIR, kindly have a look at, my lord, FIR page 8 to 10. Kindly have a look at FIR page 8 to 10, my lord. My lord, page 8, paper book, page 8. To the OC Heragat PS Police Station, Heragat, dated so as a humble submission is that at about 1 AM yesterday. That is on 29/8/96, around 45 persons of Munda community from Jamuguri village, armed with bows and arrows, guns, had surrounded the residence of our people of Horizon community, between two community fighting, my lord, mentioned below, and launched arrows and set ablaze the houses. As a result of launching of arrows, Krishna Horizon, Keshav Horizon, and Srimati Sripati Horizon sustained grievous injuries and arrows.
So
He-
you are, what is your name? You are the one who encircled the house.
My lord.
You are the one who circled the house and circled the house with bows and arrows. You are
Yes.
not inside the house.
Yes, yes, complaint says, as I says, that we the people came. We the people came with bows and arrows.
Correct.
That is the FIR, my lord. And FIR said that 45%.
But your case was that your house was burned. It's not that, it's in fact, you had encircled the house with bows and arrows. And the property caught fire.
True, my lord.
So
So
you,
far allegation-
in the first instance, you're
So
not
far-
fair
so
to the
far-
court.
So far allegation, my lord, appellant has come. Appellant
where-
has come with arrow and set fire to their houses. So far allegation, my lord. That 45 persons were in FIR, my lord. Thereafter, my lord, your lordship, kindly have a look at charge sheet, page 12. 12, my lord. Page 12, there are 18% name is my lord. Page 12, 18% have been charge sheeted. 18% have been charge sheeted, my lord. And they pay the trial. Out of 18, 13% pay the trial. My lord, then thereafter page 14. Page 14, my lord, a statement of the PWDs, my lord. PWD1, what did he say? He said, I know the accused person present in the dock. My lord, page 14. They belong to the village Jamuguri situated at a distance of half kilometer away from my village. Clearly Ganga.
Mr. Counsel, I don't think you'll be completing it today.
My lord.
It's quite
Then my
clear.
lord, kindly give a date, my lord. So
And
day after
I
tomorrow.
think even additional PP is not ready.
I am
Ready, okay.
My
Ready.
learned will always ready because she always make the case, my lord. She is with me. She is ready with the case.
So you can finish within how much? Don't, you have to give us the right time. We won't give you a second more.
আজি পাৰিব
My part I can complete today.
When, within how much minutes?
Yes, my part I can complete.
Within how much minutes?
Within, my lord, how much your lordship, before your lordship rise, I can finish.
No,
Within-
Mr. Counsel,
My lord,
Mr. Counsel,
up to
it's
four-
not
within
that.
15 minutes. My lord, within-
You see, because the additional PP also has to be heard.
because individual overtake has to
Individual, yes. You cannot
Thank you.
try to take the, you see, once you do something. We are not going to allow you to go beyond what you say.
My lord.
So if you want to do the case, we'll hear you, but then within the time limit, but we will not record anything beyond what you say.
My lord.
So please be assured that we will hear your case, but if you don't complete it, we will not hear anything beyond that.
My lord, I hope and trust I can finish within 4. Within 4, within 15.
Within
within 4.
by 4.
By 4 I can.
Cautious 12 witnesses, I don't think so, he'll be able to.
It's his risk. If he does, then we'll list it after a month. It's his risk. If he is ready for it.
Then my lord, let us do one thing, my lord, if the lordship pleased. Let us kindly adjourn and list it on Thursday, my lord. Thursday,
No,
Yeah.
not this week.
Thursday, my lord. Yes,
No,
fast
no,
I can.
not this. Today also, Mr. Anshu had made a prayer. We said no.
My lord, kindly, it's a short date, my lord, kindly,
You
because.
see, Mr. Counsel, there are other cases in the queue. Yours is of 2020. Yesterday, we were hearing a matter of 2004. No, that's not 2004. I'm sorry. It was, but the incident was of 2004.
Dhemaji bomb blast.
that bomb blast. I think 2016 or something, 14 or something.
My lord,
Huh?
kindly, my lord, on the, if it not allow on Thursday, then next Tuesday, my lord, on the hearing day. Otherwise, because my lord, one problem is there, I'm not here yet now, I used to stay at Silchar. For this case, I used to come, my lord, once again. Kindly help me, sir, also.
So what? So we'll give you a date, but doesn't have to
So,
be
my
so
lord,
early.
I request your lordship to get it listed on Tuesday, next Thursday, day after tomorrow.
No. Right. Yeah.
Or, my lord, if not possible, then next Tuesday. Next Tuesday.
No. Unless the matter on. This the matter on 15th.
15th of this month. April of life. As fast I can, my lord. Yes, otherwise, because, my lord, 2 days, I have come by Monday, as fast I can, my lord. As fast I can on hearing list, my lord, kindly help me, my lord. As fast I can on hearing list, my lord. That will help me, my lord.
Yes. Who is there? Yes.
Item 8. There is an injured witness in this case. Should not take long.
It's a case under section 302 and 143, my lord. So he has completed the sentence under section 143. He has been during the period. Now, for my instruction, he is in the jail for last 6 years, my lord. And there is only one eyewitness. And others are all hearsay, my lord. So if people also may fix a date, my lord, on any date.
No, so there is, so there's an eyewitness to the crime.
That is,
Injured witness, she
Injured
did not
witness.
see the actual occurrence,
yes.
but she was along with the deceased. There were 2 girls who were taken by the accused persons. One was killed and one was raped and left. So that the girl who was left, she had deposed. As an injured witness, dead at night, the incident occurred.
Now,
And she said that the deceased was taken this way and she was killed beside the river and her body was found there.
now the evidence of the judgment says, my lord, 376 acquitted, my lord. There is no evidence of rape, my lord. So that part is, my lord, wholly unreliable, my lord. The other part is that whether she was in the place of occurrence or not. That is the thing, my lord. She said only I heard it by voice. She does not seen the,
Anyway, you are not, when do you want?
my lord, I pray from 15, my lord.
Can't it be heard now?
It takes some,
Can be heard, I think.
it will take time, my lord, because
Take time.
I have certain judgment, my lord, which I'll rely. There are several judgments.
Well, there is nothing to disbelieve that injured witness. She is the best witness. It has more evidentiary value. Others are all hearsay. Anyway, he wants time to.
Your witness, well, on 15, my lord. And interestingly, in this case, my lord, only the appellant has been convicted, others are nowhere expert.
Well, he's an absconder, I think the other one, Madan.
Yes, Acha. The earlier case, I said that 15th, I won't be here. Because I have got to, probably I'll be out for 2 days. I thought this Thursday will be away, but we have shift.
My lord.
Probably next Thursday will be out. So after that,
So,
23.
23rd.
as regards my case, my lord,
23.
which date?
23.
My lord, it will be too delay, my lord, too delay, my case, my lord. Kindly help me, my lord, a bit earlier. I fervently request your lordship.
Okay, 20.
20.
Both the cases.
No, I don't know. His case, so,
Item number 7, my case.
yes, your case is 23.
20.
20.
20.
Well, in item 8, well, if your lordship will take it up on 22nd, my lord, then
Why 22nd? Your case is very simple.
there is a, well, 302 is not effective. My submission is.
Maybe your submission. But then this is the paperwork is less. So we thought maybe we can dispose it of earlier.
So any day your lordship may pick, because if I argue my lord, then there will be certain judgment, my lord. Because 141 unlawful assembly part, I will argue my lord, but there is no 149, common object is not there. So 141 is only unlawful assembly, whether
How many persons were convicted under 302?
only one. my
Only
lord.
one, the other one absconded. Madan Mardi has absconded, against him the case is filed.
There are 5 accused, my lord. The Madan Mardi, the eyewitness name only Madan Mardi. That he told that he will kill her sister. That's all, my lord. And the other witness is the father, my lord. See, he has not deposed in court. That is hearsay. That is my lord, wholly unreliable, my lord. That part I will argue, my lord. The evidence is wholly unreliable. If it is partly reliable, then okay, because she stated that she is injured, but judgment said that there is no injury and it's a no sign of sexual intercourse also found.
No, but injury report is there. Of PW6, exactly.
21.
Any day your lordship may convenient.
Huh?
When your lordship is
21, madam.
Any day, not so on here.
on 14 also your lordship. 14 if
No,
lordship
no,
is
14.
Tomorrow also it can be done.
No,
Hemaji
tomorrow
case.
we have already fixed 2, my dear.
Hemaji
on, my
case,
lord.
I will take around only 1 hour or so, but whatever materials I gathered yesterday,
Okay, we'll fix this on 19.
19th, Lodge.
This is the matter on 19.
I'm paying for the amicus. My lord, one thing, my lord, my case may kindly taken as item number 1, my lord, because on that day, again on 20, the same happening of what happened today, that will happen, my lord. If it goes below, my lord, time does not permit. Time does not permit, my lord. In several occasions, I face such a trouble, my lord. Time will not.
You see, there are so many appeals prior to your, you cannot jump the queue. We are 20, you wait your turn.
My lord, as item number 1, my lord, kindly.